Hey class, it's Mr. Stewart, and hopefully you guys can hear me and you can see the PowerPoint. You should be seeing the Chapter 8 for CRJ 100 excuse me, PowerPoint here. They came in and changed some of my computer equipment this week, and some of the settings were weird, so hopefully you'll be able to hear me and see the PowerPoint. So there's no actual video of me, but you will be hearing me hopefully over the PowerPoint this week. I apologize for no taking the video for last week. I was a bit under the weather and I had some computer issues, hence the changing out of some equipment. So we'll be back on track this week and the weeks following. Also, a couple reminders, or a reminder for this week. Please do not forget to take the midterm exam no later than Sunday evening. If you click on the exams tab, it should be the only exam that you will see. It either will say exam 1 or midterm exam, but it's worth 75 points. You get 3 chances to take it, and Blackboard will record the highest grade out of the 3 attempts. So make sure you get in there and get that exam taken. All right. Today we're going to be talking about some of the stuff here in Chapter 8. I'm not going to probably go in this lecture into Chapter 9. But I'm going to talk about some of the things in Chapter 8 just to make sure we're all on the same page here. This Chapter 8 has to do with courts and the quest for justice, and this is an integral part of the criminal justice system. You know, you've finished reading the chapters and having discussions in regard to the police at this point. So now, once the police have made contact with someone, they go through the court system, and the court system is another stage of that criminal justice process prior to punishment and rehabilitation if that defendant is actually found guilty. So let's talk about the courts here for a few minutes. We're going to talk about the 4 functions of the courts. Now, I'm going to digress just a little bit from the text with one of these functions, with the 4th function, because I don't even really consider the bureaucratic function and actual function of the courts. But I want to talk about these others first. And the first is the due process function. When you hear the term due process, what you should be thinking of is fundamental fairness. It doesn't matter whether you stole a piece of peppermint candy from the Shell station or you hacked your mother to death with a butcher knife. You should be afforded the same rights and privileges within the criminal justice system, no matter who you are or what your crime is. That's what we call due process. Everyone gets due process. And that means that their rights are protected and they get equal opportunity for defense of whatever crime that they've been accused of. So that's one of the functions of the courts, is to protect the rights of the accused. And honestly, if we're protecting the rights of the accused, we're also protecting the rights of all involved, because if we begin to erode the rights of the accused, then it won't be too long before we begin to erode the rights of the victims, and we erode the rights of the police, and we erode the rights of society, and then instead of progressing, we are regressing as a society. So the due process function is very important to the functioning of the criminal justice and the court process. Now, the courts also have another function called the crime control function. This particular function of the courts is basically to make an example out of those who are accused and convicted of crimes, a public example, so that other people see that person, what they did, and what the potential punishment or what the punishment is for that person, and it should act as a method and a way for more people not to go out and commit the same crime. This doesn't always work as well as in practice as we would like to think it does in theory, but that is one of the functions of the courts, is to actually punish those who were convicted of crimes so that others may see that punishment and reconsider engaging in the same behavior. That's the crime control function. The 3rd function is the rehabilitation function. This is also one that, in theory, it sounds really good, but in practice, it hasn't really turned out so well either. The rehabilitation function is simply that, to treat and rehabilitate those convicted and sent to punishment so that when they are released from prison, they can be an upstanding member of society and they don't go out and commit more crimes. In the past, historically and typically, what we've seen is we've seen a lot of money and resources thrown at rehabilitation, and we've seen less than stellar success rates, if you will. I mean, think about this. About 9 out of 10 people that go to prison will get out at some point. 7 out of those 9 will return to prison in 5 years. So we're talking about a 70%, at least a 70% recidivism rate amongst convicted felons. And that is unfortunate, and it also shows that whatever we're doing isn't working. So honestly, this particular function of the court probably needs to be revisited and new things tried on a more grand scale than what we've done up to this point, so that we can hopefully get a higher success rate. But that is one of the functions of the courts, is to line up the particular services or needs of an offender so that they can be effectively rehabilitated. And then the fourth function of the courts is a bureaucratic function. The reason I don't call this an actual function of the courts like your textbook does, and this is the first text that I ever heard it called a function of the courts, it's more like a byproduct. The larger the court system is, the larger the agencies are that handle the functions within these other functions within the criminal justice system, the larger the bureaucracy. And basically what a bureaucracy is it was designed to be very efficient. You should have compartmentalization, which means you have certain people that do certain jobs. The problem, what we've seen historically in the court systems and amongst other systems within the criminal justice system as a whole, is that there's been a lot of duplication of effort, duplication of work, that has been marked by inefficiency. So in essence, the bureaucratic function, when you have this large amount of compartmentalization, left hand doesn't know what right hand is doing, and therefore inefficiency really is kind of the norm of the day. That's really a byproduct of the larger court systems, is inefficiency. And if you don't believe that, just look at how long it takes a case to move through the system. The more complex case it is, the longer it takes. Back 80 years ago, if you were charged with murder today, they may wait a week before they took you to trial, but you would go to trial, and many murder cases had a 1-day trial. And then if you were found guilty, your punishment was inflicted fairly immediately, or within 24 hours. And then up until the 1930s and 40s, if you were given the death penalty, you were probably executed within about 3 weeks of your conviction. So that was before the time of bureaucracies, that the court systems got so large and so inefficient. And many people think that, well, that's necessary to make sure we don't execute innocent people, or it's necessary to make sure that everything was done correctly. I agree with that to a point, but I also think that we could be much more efficient if we didn't have such a huge bureaucracy within the system. So hopefully that clears those functions of the court up just a little bit. And if you have any questions about that, feel free to reach out, send me an email, call me, text me, or whatnot. So those are the 4 functions of the courts. Next thing I want to talk about is also something students get confused fairly frequently, is jurisdiction. We have basically 2 major types of jurisdiction here in the United States. We have what we call geographic jurisdiction and subject matter jurisdiction. Now, geographic jurisdiction is jurisdiction that is set apart by actual geographic boundaries, political boundaries, state lines, or the type of crime that's involved, such as if you were driving in the city of Decatur and you got a speeding ticket by a Decatur City police officer, they would not put you in court in Huntsville, because Decatur City Police has a geographic jurisdiction within the city of Decatur. If you were on 565 and you got a speeding ticket by, let's say, the Alabama Highway Patrol, what would gauge the jurisdiction where the court, which court you would be in, would be which county that you got stopped in. Would it be if it was Morgan County or Limestone County or or Madison County as to which court you would go to. And then you also have every state has a court system, a state court system, and then you have the federal court system. So if you engage in a federal offense, you don't go to court in the state court system. You go to court in federal court, because that's based upon geographic jurisdiction. You also have jurisdiction in regard to the subject matter, because lesser, more non-serious offenses will go to a court of limited jurisdiction, such as Athens City Court, or Huntsville City Court, or Decatur City Court. More serious offenses, felonies and such, go through courts of general jurisdiction, and those are the courts that have a wider ability to punish, sentence, and fine the defendants if they are convicted. So depending upon the type of crime that's committed, as well as where it's committed, will determine the jurisdiction of the court that handles that particular case. For example, if you get a speeding ticket in the city of Athens, you're going to go to court in Athens City Court, and that's not going to be in state traffic court. But if you get a DUI on 565, that's going to be in state traffic court, and depending upon the county in which you got that DUI would be which county court of general jurisdiction that you would go to. Those city courts are courts of limited jurisdiction, which means typically they cannot put you in jail for something other than maybe contempt of court, and they're also limited on the amount of money that they can fine you. So with that being said, just try to understand that depending upon the type of case and where it is committed will determine the jurisdiction of the court over that particular case. Your book does a pretty good job of describing that as well, and I just want to try to clear up that water a little bit. I also want to talk about the difference between trial courts and appellate courts. Trial courts are the courts that are concerned with deciding the question of fact. And when I mean questions of fact, I'm talking about guilt or non-guilt. Here in the United States, we do not find people innocent at trial. Why? Because the burden of proof is upon the prosecution, and the prosecution has to prove you guilty beyond a reasonable doubt. They either prove you guilty beyond a reasonable doubt or they do not. If they do not, you're not found innocent, you're just found not guilty. Now, interestingly enough, as far as punishment goes, innocence and a not guilty verdict are basically one and the same as far as punishment goes, because we don't punish people we don't find guilty. But it doesn't necessarily mean you're innocent. It just means that we could not prove your guilt beyond a reasonable doubt. Many people falsely assume that if the court finds you not guilty that they found you innocent. No, because you do not have to prove your innocence in here in the United States court system. You only have to prove guilt beyond a reasonable doubt, and if you don't convince the jury that you're guilty beyond a reasonable doubt, they have no choice but to find you not guilty. And if they find you not guilty, that just means, hey, you're not going to be punished. Doesn't mean we think you're innocent. Just means we couldn't prove you guilty beyond that reasonable doubt. So trial courts have what we call original jurisdiction. That means that's where the case originates. We find you guilty or not guilty in the trial court. If you are found guilty in the trial court, you can appeal that decision to a higher court, and those are the courts of review or the appellate courts. Now, many people are also confused that the appellate courts basically just have another court consider the facts of the case. That is not true. The appellate courts don't consider the facts of the case where the jury found you guilty. They look at errors that were committed during the trial. If those errors were fatal errors, which means they were large enough that if they had not happened, the jury would have likely reached a different verdict, then they can send that case back to be retried, or they can simply say, these errors were so egregious, they were so terribly bad, that we're just going to free you, and we're not going to send this back to trial. The jury made a terrible mistake, and you're done. So the appellate courts can make those decisions. They can also look at whether or not, or they can also decide that hey, the trial court got it right, even though there were probably some errors committed, they were not fatal errors, you're still convicted, you're still going to be punished. So those are kind of the three options that an appellate court has. Now, most states have two levels of appellate courts, which means you have the Court of Criminal Appeals, which is kind of the first appellate level, and then if you lose that appeal, you can file that same appeal or file an appeal with the state Supreme Court. And if you lose the appeal with the state Supreme Court, then you have the option of filing it with the federal U.S. Supreme Court. The U.S. Supreme Court is both a trial court for some things and an appellate court at the federal level, and it is the last court or the court of last resort for any appeal that have been denied in any state courts. That doesn't mean that automatically the U.S. Supreme Court will get your case if you've lost the appeal with your state Supreme Court. In fact, the likelihood of getting the U.S. Supreme Court to actually look at your case is very low. They get requests to hear about 25 to 30,000 cases a year, and they typically only handle about 25 to 30 cases a year. They only handle those cases that they deem have a national interest or some sort of widespread and pervasive issue within the court system. Anything else, you can pretty much figure they're going to send back to the state court, and they're going to say we will revert to whatever their decision was. So trial courts are where did they find you guilty or not guilty. Appellate courts are where they look at errors committed during a trial to determine whether or not those errors were bad enough that they tainted the jury or the decision that the jury made. This slide you should be seeing here just outlines the several levels of a typical state court system. Not every state is like this, but it just gives you an inkling, an example of what it looks like. This slide tells you about the typical state court system. It includes the lower courts or courts of limited jurisdiction, such as your city courts, your magistrate courts, or any type of specialty court. Then you'll have the trial courts of general jurisdiction. And what general jurisdiction means is that they capture more information about the defendant that goes on the record in regard to that case. They also have the ability to punish you more severely and fine you more money and send you to prison, whereas the lower courts are limited jurisdiction. They are exactly that. They're limited as to what they can do. The next level are the appellate courts, and then the state's highest courts, which is typically the state Supreme Court. This slide gives you an example of the federal court system. The federal court system, I'm going to go to the next slide here, and then come back to that one, is a three-tiered model. You'll have the U.S. District Court, which is the trial court. You'll have the U.S. Courts of Appeals, which are your appellate courts, and then you have the U.S. Supreme Court. Now, I'm going to go back to this map here for just a second. I want you to take a look at, let's look at District 11 here. That includes Alabama, Georgia, and Florida. What you're going to see is that every state, Alabama has U.S. District Courts, and they probably have 3 of them, I believe. I think you're going to see there's one for North Alabama, there's one for kind of Southwest Alabama, and one for Southeast Alabama. Georgia also has, looks like 3 levels. You see that little line there. One for North Georgia, one for South Georgia, and one for Coastal Georgia. Florida looks like it has 1, 2, 3, maybe 4 levels of trial courts. And basically that means that you don't have to go, if you get charged with a federal offense, you don't have to travel, 600 or 1,000 miles to go to trial somewhere. You're going to go to trial in an area fairly local or regional. For example, I think the closest trial court to us here is going to be Birmingham. I know if you're in District 6, which includes Tennessee, the closest federal trial court, the U.S. court, district court, is going to be in Nashville. If you get convicted at that trial court level, then each one of these districts or regions here has one level of appeal, has an appeals court in one place. You can see that is in Atlanta. So let's say you go to trial court in Birmingham at the federal level. You get convicted and you appeal it. Then you have to go to Atlanta for the appeals. If you lose that appeal, the next place you get to go is Washington, D.C. to the U.S. Supreme Court to see if they will hear your case. Now, Birmingham to Atlanta from wherever you are in this district is not a huge jaunt. But look at some of these other districts. Look at District 9. Look how large that is. Montana, Idaho, Washington, Oregon, California, Arizona, Hawaii, and Guam, the Mariana Islands, and Alaska. So let's say that you are in Nome, Alaska, which would be somewhere right above that 9 in Alaska on the map, and you go to federal court. You're probably going to go to federal court in Anchorage or Juneau, which is where the trial court is. Let's say you lose that. You get convicted. You appeal it. You have to come all the way to San Francisco, California, to the appeals court. If you are in northeastern Montana, it is a long drive to San Francisco. If you are in Hawaii or the Mariana Islands or Guam, it's a long way to San Francisco. So you can see that not all of these are necessarily that efficient, but they're based typically on population centers. You know, if you look at this district here with District 5, it only has 3 states: Texas, Louisiana, and Mississippi. Or if you look at District 2, it only has a couple 3 states there. Very, very small, but it has a lot of population. District 1 has a lot of population. The interesting one to me is that in District 1 you have Maine, looks like New Hampshire, Massachusetts, Rhode Island, and Rhode Island. But you also have Puerto Rico. How far is it from Massachusetts to Puerto Rico? That's a long way. But I don't know who thought that one up. But I would have thought Puerto Rico might be in District 11. You would think it'd be a little closer, but for some reason it's not. Anyway, so that gives you an idea of how the federal system is set up. I want to talk briefly here for just a minute about how a case is brought to the Supreme Court. I told you that they get a huge amount of requests every single year for cases, and they only hear a very small number of those cases. And the reason why is they have to kind of weed through all those cases to see if they have a national interest. It's not just somebody that's their last best chance. The Supreme Court typically doesn't hear any evidence. You don't put on a trial with the Supreme Court like you would in other courts. Typically, you would file something called a writ of certiorari. That's in your textbook. Certiorari. Certiorari. That is the request for the Supreme Court to hear the case. They will look at it. If they deem that they're interested in it, they have to vote. 4 out of the 9 justices must vote to hear that case before the Supreme Court will hear the case. So it doesn't take a majority vote, but it takes almost a 50% vote to hear it, but not quite. So something less than 50%. If they decide to hear it, then what happens is then each side will file a brief, and there's nothing brief about a brief. I've seen briefs be over 1,000 pages long, and that's simply the written document that spells out why the court should decide in your favor. Well, both the defendant and the prosecution who got that defendant convicted get to file a brief. And then at some point they will have oral arguments. And that typically each side gets about 30 minutes before the Supreme Court to say, here's why you should find in our favor. And then they will adjourn, and they will begin to talk the case out in conference. And this is why it takes a long time for the Supreme Court to come up with an opinion, is because they have legal assistants and clerks that are doing research, and because they put a huge amount of thought and study into every decision that they make. A good example is Brown versus Board of Education. This was the 1954 court case that desegregated school systems here in the United States. It was actually in opposition to a previously decided case called Plessy versus Ferguson. And so that case was actually argued in 1952, I believe, late 1952. And the Supreme Court did not come out with their opinion until early 1954. So it took somewhere in the neighborhood of about 18, 19 months for the Supreme Court to look at everything and then decide they were going to reverse a previous Supreme Court's decision and integrate schools in regard to race and ethnicity. Now, when the Supreme Court comes up with an opinion, whatever the majority rule is, 5 out of the 9 must vote one way. At least 5 out of the 9. That's called a concurring opinion. And they will basically say, here's our decision and here's why we made it. But what you also get is something called a dissenting opinion. That's any of the justices that voted in opposition to the majority. And you get the reason why they voted that way too, because you may use that later if you bring another case to the Supreme Court to help you figure out what it is, the issues that they deem to be important. What may have been one of the deciding factors or something in the case. So not only do you get why they decided the way they did, you also get why the judges that didn't vote that way decided to vote that way. And that's very helpful, helps us to understand the law. Learning Objective 7 here talks about the actions that a judge may take prior to trial. These are what we call pre-trial actions. Make sure you read over that section in your text. Look at this slide. There's also a whole chapter in regard to that as well that's coming up. Basically, these actions are what allows the courts to be as efficient as they are. Not that they are hugely efficient, but if we didn't have these pre-trial actions, there's no way we can go to trial on every single case. It's just not going to happen. So just understand that we have to do certain things prior to the beginning of trial that helps move that case through the system. Learning Objective 8 talks about the selection of judges. Read that section over. It's pretty straightforward. One thing that I'd like for you to understand in regard to judge selection is that many people don't agree with the way we select judges. Some judges are elected by popular vote. Others are appointed by the governor of the state or the president, and then they would be confirmed by the state legislature or confirmed by popular vote at the state level, depending upon the type of selection that there is. Or at the federal level, they're appointed by the president and they're confirmed by the Senate. The interesting part about federal judges is that once they are appointed and confirmed, they don't get fired. They serve a life sentence. That's not what I really meant to say, but that's what it amounts to. They serve a lifetime appointment. They can stay on the bench until they retire, until they die, or until they decide to just say, I'm done. And they're not going to retire. They just say, I'm done. They also have judicial immunity, which means anything they do on the bench in regard to a court case, any decision they make, they cannot be sued for, nor can they be removed from office for. And a new president cannot come in and remove sitting federal judges either. Once they're on the bench, they're there until they decide to leave. Many people don't like that idea because they say, well, that carries on. If you get a bad president and they make a bad choice of judges, and you have years of a bad judiciary. The other side of that would be is it allows longevity on the side of the judiciary, because if you allow the judges to be changed at the president's will, then whatever political wind was blowing at the time would be the types of court decisions that you would have, and you would not have any longevity, and things would be constantly changing. So, there's pros and cons to this whole idea of a lifetime appointment. Last thing I want you to understand out of this chapter is learn Objective 9. Who are the members of what's called the courtroom work group? When I first got into criminal justice, we didn't have this term. We just called these are the people that work in the courts. Now they've lumped them all together because actually they all work as a team. And yes, the prosecutors, defense attorneys all work together, the bailiffs, the clerks, the court reporters, and the judges. They all have a job to do. They are compartmentalized to a certain degree, and if you remove one of these, then that would lead to severe inefficiency of the court system and probably result in the trampling of rights of the defendant or victims or of society. So this is important. We call these people the courtroom work group. They all are necessary to the working of the court system. And that's all for this chapter, and that's all for this particular integrity lecture. I really hope that may have cleared up some of the muddy water. And if you have any questions, problems, or concerns, please reach out. And then chapter 9, also read chapter 9. It's important as well. But this particular PowerPoint and lecture kind of sets the stage so that you can understand the other chapters in regard to the courts. Have a good week, guys. I'll see you in discussions, and I'll be grading and responding in discussions a little bit later on this week. Bye-bye.